there. But what we're looking to cover today will be a full range of topics around employer discretions. We're going to, first of all, Jess is going to take us through what we mean by an employer discretion. Then I will have a look at mandatory, non-mandatory discretions, what the difference is, and some of the key discretions that need to be considered because of the provisions in the legislation, and what that means for you. We'll also then take a step back and look at what does a good discretions policy look like. How is that structured? What does it? How do you go about doing it? Making sure that it's compliant. And then Jess will also take us through an approach to decision making, and then how you go about reviewing the process and the publication of the documents themselves. So in terms of the agenda, as I've just said, that's what we'll cover: employer discretions, mandatory, non-mandatory discretions, what a policy looks like, decision making, and then the overall review of the process. So Jess, if I can hand over to you, if that's all right, to take us through what are employer discretions, and I'll navigate us through the slides as we go.
Yeah, sounds good. Thanks, Stu. So employer discretions, so what are they? The LGPS is a statutory pension scheme, so its rules are essentially set out in legislation. A discretion is essentially a choice that the regulations allow employers to make in areas where the rules leave a bit of room for judgment. So often you'll spot this out because it'll say something like the employer may do something, such as the employer may allow flexible retirement or may waive an actuarial reduction. It's important to emphasise that these are powers and not entitlements. So just because a discretion exists doesn't mean that a member will automatically get the outcome that they want. It's for the employer to look at the situation and decide when they're exercising that discretion what is appropriate in those circumstances. So because these are choices and they can directly affect members' pensions, and they also have financial implications for the employer, the regulations require every employer to publish a discretions policy which sets out their general approach. So this just ensures that decisions are made consistently and transparently, and that they're taken within a proper governance framework and not handled informally or on a case-by-case basis. So if you could go to the next slide, please, Stu. So I briefly touched on this, but we'll just go into it in a bit more detail. So why do discretions exist? One of the reasons is because the LGPS has to work for a huge variety of employers. So although the benefits themselves are set out in legislation, the realities facing employers can be very different. So size, budgets, workforce profiles, and various service pressures, they vary between different employers. So discretions effectively allow the LGPS to work sensibly in the real world and give employers the ability to make decisions that reflect their particular circumstances. I'll just give you one example maybe. So an employer might be able to support flexible retirement because they can reorganise their hours or their duties, whereas another employer might genuinely not be able to make that work in practice. So the regulations give employers flexibility to reach a decision on whether or to the extent that they wish to support flexible retirement in that situation. If you could go to the next slide, Stu, that'd be great. So now I'm just going to briefly touch on the difference between a duty compared to a discretion. So duties are things that an employer must do. There's no flexibility I've set out some examples on the slide there. So employers must enrol eligible employees into the scheme, pay contributions, and provide statutory information. These are all mandatory, and so employers have to do those things. On the other hand, discretions are areas where the employer has a choice. So the regulations say that employers may take a particular action, which means they're allowed to, but they're not required to do this. And we'll touch on various discretions throughout this session. It's important, though, to flag that discretions do involve a choice. They're not casual or optional, and they can't be ignored. So when a discretion is triggered, the employer must stop and think about it, weigh up the different circumstances in the situation, and then make a decision. So fundamentally, there is a decision that needs to be made. If you could go on to the next slide, please, Stu. So as we've briefly mentioned, employers need to publish a discretions policy in relation to the different discretions they need to exercise and keep that under review. And the reasons for this are, first, it creates transparency. So employees can see the employer's general approach. It helps to manage expectations and reduce any misunderstandings. And just from the employer's perspective, it also gives their managers and HR teams a clear reference point when they're asked to make these decisions. Another reason why it's useful is to promote consistency. So without a policy, decisions can vary on who receives the request or how familiar they are with the regulations, and a policy just ensures that you're effectively speaking with one voice and following a stable and consistent approach. Another reason is it ensures that decisions are well reasoned and defensible. So putting that into practice, if a member were to challenge a decision, being able to refer back to this policy will make it far easier for you to explain how you reached the decision and to justify your approach when making that decision. Stu, should I hand over to you now to talk through the...
Thanks, Jess. Thanks very much. And I think that sets the scene up quite neatly, that when so more generally dealing with discretions, that because it's something which potentially could be subject to review, subject to challenge. It's not a binary point. It's not something where the rules say you have to do X or Y, but rather there is a judgment call. There is a basis on which to decide whether or not to provide a particular benefit, or as we'll see in a moment, if that decision is taken, what level of benefit that might be provided. There will always be potential for an individual to, or group of individuals to question the basis on which that decision, that discretion was exercised. And so there's a number of factors at play here. A key one is, as Jess has mentioned, is making sure that the right processes are in place, the right governance is in place, and ensuring that there is the policy documentation there is key to that, both from an audit trail perspective, but also to support consistency of decision making. So whilst on the one hand, there is a obligation under the local government pension scheme regulations to have a policy in place that covers certain discretions that are provided for in the rules. More generally, and we'll come on to this towards the end, it's a really important document and process to have in place, and which is also reviewed. Again, we'll touch on that towards the end. These don't necessarily have to be, once and done, but it is important that they're kept under review, and also that your teams, your decision makers, are fully aware of what's in those in the policy documents. But what I'll do now over sort of the next few slides is we're going to do a bit of a drill down into what these discretions are, what they're how they're provided for in the regulations. And as Jess has mentioned already, we've got a sort of bit of a split because of the way that the regulations work. Some are expressly listed to be mandatory discretions that we need to cover off in terms of the policy. There are other examples of what are described as non-mandatory discretions, so that where you don't have to provide for it in the policy, but nevertheless it will be good practice to do so. So mandatory discretions, and this is for those of you that are sort of following along at home in terms of your regulations, it's regulation 60 if it ever comes up in a pub quiz, or it's just one you want to refer to at any point. But regulation 60 confirms that it's the scheme employer, your employer, must put together a written statement, and these cover certain mandatory discretions. Now, as a heads up, the ones that we will look at, there's discretion around the funding of additional pension for members. There's a discretion around flexible retirement. There's discretion around waiving an actuarial reduction. So when somebody goes on early retirement, their pension would be reduced for early retirement, but there are certain circumstances where that reduction can be waived, and therefore the member gets an improved benefit in early retirement. And also a discretion around the award of additional pension. So slightly different from the funding of additional pension, but the actual award, so a decision to provide an individual with more benefit without them having to contribute towards it. So those are, as a heads up, those are the main mandatory discretions that need to be reflected, and where a policy position needs to be taken, and that needs to be recorded, and needs to be kept under review. Then there are some non-mandatory discretions, which might relate to how you might put somebody in different contribution bands depending on salary, pensionable pay changes during the course of the year. We'll come on to some examples in a moment. But these, when we get to them, non-mandatory discretions, they're not legally required to be in the policy that the regulations require you as employers to have in place. But we would typically see, and I think more generally across funds, we'd see it's good practice, it's best practice to include discretions that can arise frequently or have material cost implications. Again, this comes back to the governance and the audit trail for your own decision making, because as you'll see, there's a general theme here. The exercise of these discretions will likely increase the liability, increase the funding costs that you have to meet, and therefore making sure that you've got clarity of process is important. It's all about ensuring consistency, helps with managing expectations as well. So when you're perhaps picking up questions, or you might be engaging with groups of members and your employees in terms of what they may or may not be able to do, or how they're being treated when it comes to contribution banding or the ability to pay additional contributions, you've got the policy that you can reference, and that will sort of help, rather than it being almost a case of, well, we need to review this as and when individuals come through the door requesting a particular discretion is exercised for them. And all of that comes together to reduce risk and manage the risk of challenge at a subsequent point. So bit of detail now of the next 9 or 10 slides, where we'll just look at each of these mandatory discretions in turn. The way we've structured this, we'll give you a summary of what the discretion is, what the policy would need to cover off. And then we've got a couple of examples for each one of the sort of approach which we would see in terms of how that discretion is documented in the policy. So the first one here is sharing the cost around additional pension contributions. So employers are required, must publish a policy on whether the employer will themselves contribute towards additional pension contributions, the APC, which is probably a term that you'll have come across in the past. And that is where an active member, they're building up their service, but they want to buy additional pension. And then from a discretions point of view, the employer can choose whether or not to share that cost and make a payment towards that additional pension that members would be securing. And they do that by paying their contributions. You can set limits, you could set conditions, you could set eligibility criteria around the choice about sharing cost for those additional pension contributions. The actual level of contribution that needs to be paid will be set in line with actuarial factors, which are set within the scheme and with input from Government Actuaries Department, for example. But nevertheless, this point is more about will the employer exercise a discretion to share that cost in some way. And factors that you might think about here: clearly the actual cost to you, and that will vary depending on the member's position and the member's age. It might vary depending on how much the additional pension the member's looking to secure. Current limits, they can potentially secure additional pension through their contributions up to £8,903 there and thereabouts. It increases over time by reference to the increase levels that apply under the legislation. You might consider, for example, sharing cost as a part of a recruitment strategy, as part of a retention strategy, maybe as part of loyalty, long service. But also bearing in mind there could well be tax implications in terms of how you're meeting those costs, how you're sharing those costs, but also there's also potentially tax implications for the individual themselves. So these are some examples that we often see in range, and you'll pick up a theme as we go through these discretions more generally as the type of approaches that are taken by employers when they're setting these down in their policies. You could have a very simple statement that just says, the employer won't normally contribute towards the additional pension contribution, the additional pension purchase. It would only be in exceptional circumstances. So the point here is leaving it open to say, we might do this, but it would be exceptional. Perhaps better to do that rather than saying we will never contribute to additional pension contributions. If you are minded to say we will never do that, it's something you might want to think about, maybe take a bit of a view on or seek some guidance, because there's always the possibility that if you're saying, well, you've got a discretion, you could potentially do something, but you're saying we will never do it, that might be seen, and we'll talk about this later, as just sort of limiting or restricting your discretion. So leaving the door open to exceptional circumstances will be something you might reasonably think about when, even if your starting point we wouldn't normally share the cost of additional pension contributions. Another example is where you consider paying it where it's in as the employer, your financial operational interest to do so. So that might be because it helps manage perhaps headcount over time, because it will enable somebody to reach retirement a little bit sooner, or it might incentivize somebody to stay in the business for a little bit longer, because they know that if they stay in the business, then the employer is going to support them in terms of securing those additional contribution. But again, always making sure that it's going to be assessed on an individual basis, rather than having a blanket policy that says, if the following criteria are met, we will always do X or Y. That, of course, is an approach which is taken in this example given in example 3, where the employer is saying we will contribute a given percentage towards the cost for employees if they've got more than a particular number of years of service. And so that is a little bit more, should we say, well, I suppose it's clearer for an individual member. It's clear for the business as well as to when this will be done, and so it might help in terms of costing. But any one of these 3 perfectly fine. The key point is that you've got something down in terms of your approach. The next mandatory discretion that we have to have, flexible retirement. So this is an option, or it's a discretion that could be applied where an individual is still in your employment. They've been an active member. The member is then reducing their working hours or their grade of employment. So you've got that reduction in hours, maybe a reduction in responsibility or grade, therefore, hand in hand, a reduction in remuneration. And the flexible retirement provision allows, in those circumstances, if the members reach 55, but just as a flag, that will increase to age 57 from April 2028. If the members reach that age, then they can take retirement, they could take their benefit whilst remaining in your employment, so not having to retire in the traditional sense. Now, in these circumstances, you can allow the members to take all of their benefits or perhaps part of their benefits, depending on when they were built up and the different sort of benefit structures that exist within local government pension scheme and when they were accrued. But as part of this discretion, you can consider waiving the reduction that would otherwise apply. So sort of two discretions here, really. One is around whether or not you allow flexible retirement, and the other factor is whether or not you will waive the actuarial reduction that exists that would otherwise apply if somebody was taking their benefit before their normal retirement date. Again, what were you thinking about here in terms of setting this policy or your approach? Clearly, cost is a factor, because meeting the cost of an unreduced pension from potentially 55 is not necessarily an immaterial cost, very much depending on, of course, the length of service and the level of benefit the individual has. You're also looking at what works for you operationally. Is this going to work for you? Because it allows you to, again, retain somebody in the business. They don't necessarily want to work full time, but you can keep their experience, their seniority, or it might be part of a handover to another group that are coming through. That's a retention of knowledge in the business. All would be good reasons as to why you might do this, but the individual themselves wants to reduce down a little bit, so you can help by saying, well, we match that up with the flexible retirement, so it eases the individual into retirement. So there may be very good business operational reasons as to why you want to do that. Discrimination often comes up in this one because you're talking about potentially allowing somebody to go maybe in their late 50s. What are the terms on which you let the individual take the benefit of flexible retirement? So we just always have to have an eye to whatever criteria, whatever policy you adopt here, recognises the risk of setting anything by reference to age itself. Probably want to avoid that. Maybe looking more around what is appropriate for the business in terms of the actual delivery of what you need, maybe around loyalty, around transitioning somebody into retirement. And obviously the overall governance, because again, we'd often, I won't go into too many war stories today, but you'll often see decisions being taken by different parties within an employer, within an HR function, that decide, well, we'll let Janet go, but not John, and this. But it's no real structure to it, and it might just depend on discussions or promises that were had 3 or 4 years previously. So it's really important that there's good governance around these decisions for consistency. Even if you've got two individuals, same situation, one gets flexible retirement, the other doesn't. But if you're applying the same sort of policy and principles, then that's important because that supports the decision making. So a bit of a text-heavy slide here, but as Joe mentioned earlier, the slides will come out afterwards, so you've got them there for future reference. But again, just some examples of the sort of approach which we often see taken with policy approaches here. We've got sort of 4 examples all told. There's a couple on the next slide as well. The first one here is that the flexible retirement is only allowed where it's justifiable financially or operationally. So again, normally what we would see here is looked at it on an individual basis. Is this somebody you want to keep in is it within the business? But equally, is there a financial case for them to do so, for you to do so? So potentially, if you are waiving actuarial reduction, there'll be a cost, but are you recovering that cost, if you like, by the individual staying in the business for longer? What we would typically see is we've got here flexible retirement decisions require the approval of a designated senior person, senior officer. Maybe you, for your own structure, you would have a particular role, a particular position that you'd name there. Always better to name the position rather than the individual, obviously. And then that would also include approval for any waiver of the actuarial reduction. The next example, again, looking at whether there are specific provisions. So you might say, well, you consider it for active members aged 55 or over. That's fine from an age perspective because 55 is effectively the minimum age currently. And looking at it, considered if the individual reduces their hours by a minimum of a given percentage, or if the reduction in their grade or their position is by more than one level or a particular number of levels, depending on your own structure, again with a need for financial and operational support. This particular policy also references that the employer might waive reductions in whole or in part, so you don't have to go all the way, but only where it's financially, operationally appropriate to do so, or in this case, referencing compelling, compassionate reasons. That opens the door to maybe something which is a bit more on an individual basis, depending on the person's personal circumstances, that there might be a desire from the employer to support somebody as they perhaps step down. Maybe it's to help out because of requirements at home, looking after an elderly relative, but having this flexible retirement will enable them to keep them within the business. The next couple of examples, all very just slightly different. The example 3 here, looking at flexible retirement on a case-by-case basis, but then sort of being a bit more specific that pre-2008 benefits have to be drawn, maybe some flexibility on subsequent benefit accrual, recognising that reductions will normally apply in full, so a bit more of a description there, but potential to waive it depending on the particular case that's put forward. And then example 4, really sort of heavy on the governance here, requiring a business case demonstrating the financial and operational benefit, and again a reference to potential waiver of reductions only where there's a compelling business case or compassionate justification, but really sort of getting into sort of more specifics here, that where reductions are waived, the business case must set out the level of reduction to be waived, and that requires again approval from senior officer or committee. So again, not something that you would just want to wave through given the consequences of cost, but also consistency if one individual sees a colleague takes flexible retirement and they might think, well, it's equally available to me. It's important that employees equally are fully aware of there being a separate process. I've sort of touched on this one already, so won't go over it in detail again, just because in the interest of time. But as mentioned, that ability to waive actuarial reduction applies whether it's flexible retirement or an early retirement more generally. Employer has discretion to waive early retirement, whether in whole or in part. So you could go part of the way there, and you can apply limits or conditions to that waiver. Again, very similar in terms of cost strain. We sometimes see this in policies referencing the employer considering exercising a discretion, again on sort of compassionate grounds. So it might be that an individual doesn't qualify, but they don't meet the ill health early retirement criteria, for example, because they are still able to continue in work, but they are limited in terms of what they are able to do because of a medical condition. And in those cases, sometimes we'd see that that might sort of amount to a compassionate or exceptional circumstance where we've seen employers look to exercise a discretion accordingly. So again, very similar to the ones we've looked at already. I won't go through these in detail. Very again, consistent with the ones I was referencing around flexible retirement. The main point here is just to remember that when you're setting out your policies, this is a separate discretion. So you've got flexible retirement, but also the waiving of actuarial deductions would apply not just on flexible retirement, but also early retirement more generally. Okay, so the next one is all around the award of additional pension, so additional annual pension. Now, this is slightly different to the additional pension contributions I mentioned on the slides a few moments ago. This is more about a sort of essentially just an uplift to an individual's pension. It might be that they've, it's a decision to award additional pension to an active member. So whilst they're still in service, they're still building up their benefits, and then there's a decision to provide them with an additional amount of pension. So not an additional number of years or anything like that, but just a pound amount that will be added to their accrued pension. Another option is employers have the power to award additional pension to a member within 6 months of them leaving. So if they've left on grounds of redundancy or business efficiency, or by mutual consent for business efficiency, then there is an ability within 6 months after that termination date for employers to decide to award additional benefits to the individual. Again, you could set limits, criteria around this. The additional pension here is funded entirely by the employer. So unlike the APCs where it's employee pays, but you might choose to share the cost, in this case it's the employer paying, and that could potentially involve pretty substantial cost implications. The maximum currently, again, is just under £9,000, which could be added to an individual's pension. The cost of that would have to be looked at and get, from your perspective, you're looking at the funding costs with actuarial support. But affordability is clearly a relevant factor here. If you're going to award additional pension, it's going to be an upfront cost to the employer. So you need to have think about realistically how often this may or may not be used. Some employers will again look to use this or reserve the ability to use this discretion in very limited circumstances, exceptional circumstances, compassionate grounds. The thing about exceptional circumstances, of course, it's easy to state them. We will do this on exceptional circumstances, but when you're implementing that policy, this isn't really for the policy itself, but more generally, keeping a sense as to what you consider to be exceptional. Now, you don't need to put that level of detail in the policy itself, but from a decision-making, a governance point of view, it will be important that you're keeping a track as to what criteria, what principles you take into account and consider to be exceptional. Again, not going sort of delving into war stories too much, but I had an instance. This was actually advising an employer rather than the fund, where they had a number of early retirements where they wanted to give additional pension, and the certain individuals within HR team wanted to be able to do this, but they were sort of doing almost as a matter of course. And so that did beg the question as to, if you do this quite frequently, does it still qualify as being exceptional? And that led to sort of again a review of their policy and their approach to implementing the policy, and really sort of testing what conditions you would, as a business, as an employer, consider to be exceptional. You also need to be thinking about, what is fair, what is, are there any issues around equality, looking at how you are awarding an additional pension, should you do so. What you don't want to do is end up in a position where the implementation of your policy inadvertently, unintentionally favours a particular group or disadvantages a particular group. Maybe, they are within a given cohort that has a particular age criteria or condition around it, or be careful not to implement the policy in a way which might have a disproportionate impact on people that work part-time, for example. So just having it within the policy is one thing. How you implement it, really important to make sure that it's objectively justifiable and defensible. Have you got a good record of why you're taking those decisions? But Jess will come on to some of that in a bit. Also, tax implications. There could well be tax implications for the member. An increase in the annual pension would be relevant for that annual allowance position. It's not really strictly an employer point, but definitely something that you would want to flag, and it might be a consideration when you are setting the level of any additional annual pension which is awarded under this discretion. So some example wording again. Similar to others, we'd see a range. So an employer might say exceptional circumstances where there's a clear business justification or compassionate justification. So that's sort of adding a little bit more than just saying exceptional circumstances only. It's giving you a bit more colour around there being a business need or compassionate grounds. It might be that you limit it simply to where there's a termination on grounds of redundancy or business efficiency. But often we always sort of suggest, or obviously for employers to take their own view and own advice, but always useful to have something around here around subject to affordability, because depending on how costs work or funding works or the state, the cycle the business is in at a particular time, what might be affordable one year, less so subsequently. So again, what you absolutely don't want to be doing is finding that your policy in some way sets a precedent or indicates there's a precedent that something will always be awarded when certain criteria are met. And then the last example here, any award only limit for a limited amount and must be supported by a business case which is approved again at a senior level. So having that limitation but also that control around the process is really important. So the point we're really making here is definitely, these need to be covered off in the policy. You can make sure you're describing the criteria that you may need to have satisfied, but you don't need to be overly prescriptive to spell out exactly when or you won't exercise the discretion. But it is important, nevertheless, that you've got something down on your policy that gives you that recognition as to how you will go about making the decision. The last one, in terms of the mandatory discretions, relates to the rule of 85 in local government pension scheme. As we know, that the local government pension scheme rule of 85 was turned off, I suppose, in terms of accrual several years ago now, but it is still possible for members who built up benefits between April 1998 and the end of September 2006. Typically, if somebody retires between age 55 and 60, the 85-year rule wouldn't automatically apply. So, just for absolute completeness, this is where years service plus age, if it equals 85 or more, then the individual could access a benefit without reduction for early payment. If you're between 55 and 60, the rule of 85 wouldn't apply automatically, so there would be an actuarial reduction for early payment. Benefits would be reduced. However, there is employer discretion to allow the rule of 85 to be switched on to apply for individuals between 55 and 60 if they've otherwise sort of built it up, that they've accrued the potential to be considered for it, or if it would otherwise apply to them, for example, if they were at 60. It's not a right between 55 and 60. It is a discretion, and therefore one that you would need to reflect. It's one of the listed mandatory discretions you need to reflect in your policy. Unsurprisingly, strain cost is important. Again, what are the sort of workforce planning implications you might have? Is this going to help in terms of supporting a restructuring? Does exercising this discretion mean that you're able to move somebody into retirement or support them moving to retirement at an earlier age, but the funding strain, the cost is recovered by the restructuring that's carried out. It might also avoid future redundancy costs if you're able to reduce headcount, if that's what's needed at a particular time, by taking decisions and opening up the rule of 85 for somebody who's maybe a few years away from reaching age 60. So again, similar approaches in terms of whether or not the rule would be switched on. Again, looking at financial operational business cases or compelling compassionate case, always needing sign off. And these examples, which again we'll send through so you can see the sort of approach which might be taken elsewhere, who goes about making the decision, what sort of circumstances would be involved, and if there's a financial cost, does turning this on and letting somebody go early, is that going to sort of be justifiable on cost grounds? So some useful ones there, but one we typically see is where there's a need to support future restructuring, headcount, or maybe supporting an individual to limit the need for redundancies at a subsequent time. So those are the mandatory discretions. I've just got a couple of slides now on some of the non-mandatory discretions before you've earned a break from me and we pass back over to Jess. So non-mandatory discretions, just as a reminder, these strictly speaking under Regulation 60 aren't specified to be in your policy, but we would always advise that they are covered. The first one here is contribution banding. So as you'll know, the regulations set contributions that apply depending on where an individual's salary, pensionable pay sits, which band it sits in. But there are discretions around what happens if there's a mid-year correction or a mid-year adjustment in terms of somebody's pay, where there's a change in employment or a material change to an individual which affects their pensionable pay during the course of a year. Then the employer may determine that the contribution rate from a different band applies to that member. So again, that's something which, from an HR perspective, from a payroll perspective, it might be something that you offer or you would want to do. Doesn't need to be specified in the policy, but worth including, again, for fairness and equality considerations. It gives you that clarity, gives you some predictability from an HR perspective, but also from a payroll angle as well. Shared cost additional voluntary contributions, different from the additional pension contributions. This isn't necessarily securing a particular level of pension. Will the employer contribute towards the AVCs? If so, what levels, what costs, what is deemed to be appropriate from your overall approach to remuneration? Then we've got a couple of more technical non-mandatory discretions. One is where, so the concept of the APCs, the additional pension contributions that I mentioned earlier, there is an ability for an individual to elect, or if they've been absent for a period of time and they've not been building up their pension, there is an ability for them to come back and pay additional pension contributions when they return from that period of absence. This doesn't apply where there's illness, injury, child-related leave or forces-related leave, because that's dealt with elsewhere. But this is, maybe somebody's been absent because of a sabbatical or something. They come back and then can they pay their additional pension contributions to increase their benefit. There's a 30-day window for members to select this. The discretion here is, would employers extend that window? Again, might depend on the need for that person to be in the business. It might look at what is efficient for you, but again, consistency of decision making and recognizing this in the policies is relevant. Might not be a discretion you come across very frequently. Notwithstanding that, useful to have in there because, you know, even if it's not one that's used frequently, at least it's there as a reference point should the question arise on an individual case. The ability for members to transfer pension rights into the local government pension scheme, there's a 12-month deadline for doing so. Question there, you know, a discretion there, whether or not you would allow an individual who's outside of that 12-month time frame to transfer in. Need for agreement from the fund as well, which is an important factor there. And then these last couple, there's ability for individuals, so if they're a deferred member, they've come back to active service, they can aggregate their benefits. You can, if you've got post 2014 deferred benefits, the automatic, the starting point, the default position is to be aggregated. An individual's got 12 months to elect not to aggregate. Might be reasons why they want to do that. As an employer, you can extend that 12-month time frame. On the other side, for pre-2014 deferred benefits, it's not automatic. The individual has to choose to aggregate. So you, as an employer, could extend that 12-month limit for them to make that decision. Again, is that something which you would be prepared to offer? Is there a business case, or is it a once and done? No, if you've not done it within the 12 months, you know, you've had an opportunity. We're not going to make any exceptions. We've got instances, so lump sum payments in assumed pensionable pay. So assumed pensionable pay relevant in the case of family leave, for example, and it's where you've got an individual that might have received a lump sum payment. Should that be included as part of the assumed pensionable pay when you're working out there, that, you know, that's relevant to pensionable pay during a period of maternity leave, for example, and it's relevant there for you to think about what is regular. What do you consider to be regular for these purposes? What sort of lump sum payments might be decided to be included for these purposes? And then lastly, there's a discretion here where when you're looking at the assumed pensionable pay for a period of absence, if it looks like the recent earnings were unusually low, maybe due to an earlier period of absence, then you've got discretion to apply their assumed pensionable pay at a higher level. And again, that's a discretion that you would have if you wanted to do that. Quite often on an individual basis, you know, it's less likely to be on a group basis. But looking at what do you need to be able to demonstrate that the earnings that were unusually low, why was that, you know, what made it you know, less typical, and are there particular compassionate grounds that you might want to therefore award the higher level of pensionable pay. So these very much go hand in hand with HR policy, overall remuneration policy, maybe period, you know, a family leave policy as well, but making sure that these discretions are recognised in some way. Okay, well, that's been a run through both the mandatory but also some of the key non-mandatory discretions. I hope some of that's helpful in terms of maybe it's just a refresher or a reminder as to what the discretions are, but also the sort of approaches that we would see being taken. You'll be delighted to know that Jess is now back on to take us through the practicalities of this. So over to you, Jess.
Thanks, Stu. So next we're going to look at what does a good discretions policy look like. So a good discretions policy is one that, as the slide says, is clear, transparent and defensible. Once employers have prepared their discretions policy, the regulations require that it is published and that a copy of the policy is also sent to the pension fund. So in this case, employers should send it to Shropshire Council. Employers must also keep their policy under review, and as and when updates are made, the revised version should be submitted to the fund within 1 month of making those changes. A strong policy is not generic. It covers all the mandatory discretions that Stu's just gone through, and also the recommended non-mandatory discretions that are relevant to that employer. It should tell staff and managers exactly how to approach each discretion, including any criteria, limitations, or approval routes, similar to those examples that Stu's just gone through. It's also important that the policy is legally compliant. Employers can apply discretions differently for different groups or different posts, but only if that's objectively justified and it's not discriminatory. So employers must also be mindful when exercising a discretion whether doing so could risk a serious loss of confidence in the public service. And that phrase, risk a serious loss of confidence in the public service, is something that's expressly set out in regulations that employers must consider. If we could go on to the next slide, please, Stu. So we're just going to touch on the various different points in relation to decision making. So the first is fettering. So fettering a discretion essentially means closing your mind to the possibility of making a different decision in an individual case. It's important that employers keep an open mind when considering a discretion. So the policy essentially sets the general position, but employers should be prepared to take a look at that, and if there's a good reason to depart from that position in a specific case. So for example, if the policy states that an employer will not normally waive actuarial reductions, this doesn't mean that an employer will never do so, and it leaves a bit of room to, in, I don't know, exceptional or compassionate circumstances, to waive that actuarial reduction. Kind of just pulling out this point a bit more, so not fettering a discretion also means avoiding rigid and blanket rules, and ensuring that the discretion is not determined without reference to the facts of the particular case. If we can move on to the next slide, please, Stu, that'd be great. So this next slide just looks at what good decision making involves. So the decision must be made by the correct authorised person. So only an officer or committee member named in the individual employer's policy has the authority to exercise that discretion, and a decision made by someone without that authority would be invalid. The decision maker should direct themselves to the correct law. So they should identify what the correct regulation is, try and understand what the discretion allows them to do, and also understand the limitations in exercising that discretion. It's also important that the decision maker considers relevant factors only. So Stu touched on a few of those considerations earlier in the session. So that includes things such as strain costs, the operational impacts, if there's any compassionate reasons for granting that discretion, and what's fair. But importantly, it should always align with what the discretions policy says. Irrelevant factors should also be ignored. So some examples of irrelevant factors might be personal preferences that that individual decision maker has. They should avoid any external pressure or grudges that they may have, and basically ignore anything that's not directly connected to the merits of that individual case. The next thing is that the decision must not be perverse. So a perverse decision is one that no reasonable decision maker could reach. So it just kind of touches on the point that it needs to be objective and reasonable and fair. And importantly, especially for having an audit trail, the decision should be recorded, and also the reasons for reaching that decision should also be recorded. And that's purely to protect both the employer and the member, in showing what evidence was considered when they reached that decision, how the policy was applied, and to show that the decision they made was fair. If a member ever complained, it would allow the employer to show how they reached that decision and justify their approach. So yeah, be useful in regard to that. Are you okay to go into the next slide? Thanks, Stu. So this slide, and I'll probably just, in the interests of time, let you take a look at it in your own time, but it tries to set out the steps that you should go through when deciding whether or not to exercise a discretion. It's just a nice little flow chart that'll hopefully help out. And then finally, before we go on to questions, I'm just going to touch on the review process. So as I briefly mentioned, employers must keep their discretions policy under regular review. So this isn't optional, it's something that you must do. And whenever you change your approach or there's restructures or updates to HR policies, anything like that that might affect the discretions and how they're exercised, the policy should, or it's a good opportunity to consider whether or not the policy is still appropriate and whether or not it needs to be revised. And as I previously mentioned, once you update your policy, you must make sure that a copy of that revised policy is sent to Shropshire Council within 1 month, and also that you publish that revised policy. It would also be helpful to notify members of those changes too. And as I mentioned previously, it's also important that decisions and policies don't risk any serious loss of confidence in the public service. So that's a factor that should always be considered when deciding whether or not to make any changes.
Great, thanks, Jess. That's really helpful. Some really important points there. What I might just do, got a question that's coming, which I'll come on to in a moment, but I might just sort of pick up one point on this slide, which Jess mentioned, which is I suppose 2 points really. One is, again, to just stress that having a policy in place absolutely necessary to ensure compliance with the regulations, and the fund will absolutely need you to have that in place, sort of as a it's not just a nice to have, it is a required document. But as above and beyond that, the decision making process and decision making route is critical, because I'm often asked, well, so if we don't have the policy, okay, well, what's the issue there? The answer is, as I say, one is yes, you need to have it, but also there's a serious risk of non-compliance. And if you don't have the policy in place, or your policy isn't up to date, and there's a challenge to a decision, it might be that the overall decision that you've taken, or the end decision, if you like, whether or not to enhance somebody's pension, or whether to allow somebody to take flexible retirement without a reduction for early retirement, the decision might have been perfectly respectable in terms of the outcome. But if the process that's been followed is in some way tainted, or you don't have the policy, or you don't have a record of the factors that have been taken into account for those decisions, it's actually the process itself, it's the procedure where we see challenges come in and might trip up a position, rather than the final decision itself. So what I would say is that, again, typically looking at discretions more generally from a legal perspective, whether they're being reviewed by the courts or by an ombudsman or by another party, it's unlikely, so long as the decision that's been reached isn't irrational, isn't perverse, then it's unlikely the final decision would be overturned, provided the procedure itself is on solid ground and is covered these points that Jess has set out on the slide here. So I just wanted to sort of flag that it's the process which is really important, and the policy is clearly a key factor in that. And then the other one, just as Jess was chatting this through, which reminded me that sometimes we get asked, which is how you go about recording the decision as to whether or not you've provided a benefit or how you've implemented a part of the policy. And recording decisions and setting out reasons is quite an art form, I suppose, in that where there again could be challenges that we've seen in other circumstances where an individual's asked for information about their decision. Maybe they didn't get their early retirement enhancement, maybe they didn't get their flexible retirement, maybe they didn't get the additional pension and redundancy. So they're challenging, well, why not, when so and so over in another team or department got it. If the records, if your sort of notes of the meeting or the notes of the decisions just say in X case not awarded, in Y case awarded, there's a real risk that could be challenged because the courts, the ombudsman, don't have clarity around what was taken into account. At the other extreme, as I'm sure you're guessing I'm about to say, what you don't want is that the War and Peace version of what was considered or why this hasn't been provided or why it was provided for a particular individual, because that might sort of start to bring in different arguments, decisions, factors that potentially to wider challenge. So there is the point that we're making here is a very balanced, nuanced approach to how you record these decisions and making sure that the reasons which are recorded are entirely objective, they're justifiable, they're supported by evidence, but don't feel like you need to have written a mini essay about whether or not to award a particular benefit or exercise discretion in a particular way. But absolutely, always, what I would always advise people is what you write today, just have a think about how somebody would be reviewing that or reading that in 5 years' time if they were challenging it, and are you comfortable with how that's documented? It's not specific to the policy itself, but I think it's absolutely key to overall approach to decision making. And as Jess said, we've got to that flow chart, which you will undoubtedly have your own governance steps and audit processes, but something along those lines, but with the relevant people, the relevant decision makers identified along the way, will certainly help you in terms of demonstrating that a due process was taken when you're implementing your policy. So in terms of some questions, we've had one in about whether or not it's possible to specify the percentage reduction on a benefit, or whether that's mandated somewhere. So I'd say that in terms of an early retirement reduction, the early retirement factors that would apply, they are set essentially by the Secretary of State. So with their advice from their own actuarial department, the Government Actuaries Department will set factors. So they will apply in terms of the reduction that is applicable if somebody is going at age 57 or 58, for example. However, if you are minded to, or if you're, you applying your policy, looking at particular circumstances, you felt that you would give somebody an enhancement by not reducing their pension, or as mentioned in one of those examples, not reducing it all the way, then you could exercise your discretion to say, we will only apply 50% of the reduction, for example, that will otherwise apply to a 57-year-old who's taking their benefit early. So the starting point is those factors are set centrally, if you like, but when you're exercising a discretion here, you've got that room to either waive the reduction entirely or to just say, well, we'll only apply part of it that would otherwise be applicable.